In this lecture, we are going to learn about presumptions and the rules of statutory interpretation. There are certain rules which are presumed to apply in relation to certain cases without the help of any statute or case law. Presumptions are normally applicable as long as there is not a piece of legislation or evidence that proves the contrary. In such a case, presumption may be disapplied. Some presumptions may have been disapplied expressly by a certain statute. In such a case, there will not be any presumption applied in the related case. For example, it is presumed that the legislation will only apply prospectively, that is, only in relation to future cases. However, there are statutes which expressly apply the legislation retrospectively, that is, to the past cases. Presumptions are a kind of rules which are needed to be kept at the forefront of their minds by the courts as well as, of course, by the students of law. Following are the few presumptions which you should be aware of, although the list is a lengthy one. Presumption number 1. No statute is applied retrospectively. When the Parliament passes any laws, they will only apply prospectively. However, there are certain statutes which expressly provides for retrospective application. One such example is that of the War Crimes Act 1991. The Act allows the prosecution of those war criminals who are suspected of committing atrocities during the World War II. Common law is not altered by a statute. However, where a statute expressly alters any previous common law rules or principles, then this presumption will be disapplied. No offence without guilty intention, mens rea. There is a presumption that unless there is a guilty intention in criminal matters, the law will favour the accused. Mens rea may not be defined or explained in the statutes. For example, in the case of Sweet and Parsley, a school teacher was convicted of drug offences despite the fact that she was not aware that her tenants were growing cannabis in her rented property. The House of Lords overturned the conviction in light of this presumption. Lord Diplock stated, "A general principle of construction of any enactment which creates a criminal offence is that they are to be read as subject to the implication that a necessary element in the offence is the absence of a belief held honestly and on reasonable grounds in the existence of facts which, if true, would make the act innocent." Presumption number 4. Legislation is presumed not to apply to the Crown unless there is a clear provision in any given statute. Presumption number 5. It is presumed that any legislation passed by the Parliament will not be in breach of the international obligations of the UK or other countries. Another presumption is any ambiguity in criminal cases is construed in favour of the defendant due to the fact that the defendant's liberty is at stake in criminal matters. There may also be other serious consequences, including social and financial, in case of conviction of the accused. Another presumption, established and vested rights of the citizens cannot be interfered with at any pretext. There is also a presumption against depriving the citizens of their property. Presumption number 8, final for our lecture. The jurisdiction of the courts cannot be ousted. It is presumed that the final decision in relation to the jurisdiction of the courts rests with the courts. Now, you may want to look at the rules of construction, the language rules, and the interpretation approaches that we have learned so far. Please do not again forget to undertake exercises and quizzes to help support your learning of the fundamental rules of statutory interpretation.